everyone hear me? Yeah? Okay. So, I'm Mike Slavin. I was back in America over Christmas and talking to friends, and they were asking me, well, what do you do? What do you work on? And I said, well, a strange thing happened that I've sort of become an expert on how the British immigration policy system worked in the 1960s, which I hadn't exactly expected, right? Our research always goes in kind of spontaneous directions. Sometimes we become experts about things that we hadn't really intended. But in my case, this has sort of happened at a moment of peak political relevance for what was going on in the 60s in immigration policy because of the Windrush Scandal. So I want to talk about the work that I specifically have been doing in this collaborative project, which is called Seeing Illegal Immigrants, State Monitoring, and Political Rationality. All the text here to acknowledge the fact that this is not my project only. It was led out of the University of Edinburgh by Professor Christina Boswell. Our participants have now kind of scattered to the four winds. I'm here. I have collaborators in Germany and France now, but I'll talk mostly about the UK case study, which is what I led. So just to kind of orient everyone around the major project questions. There's been a lot of attention recently toward the concept of irregular entry to Europe overall, and I think Ben Hudson will talk a bit about that later on. There's been somewhat less attention recently to this question of, well, what about the people with irregular status or no immigration status who are already in Europe? And we've explored this because it opens up some interesting questions around the issue of, well, what do states seek to know about their populations, right? There's an assumption sometimes that states always want to know more in order to exert greater control over their populations. But are there times when actually it suits policymakers or states not to know what's going on? Might they remain strategically ignorant about issues where perhaps knowing about a problem could expose policy failure, like the existence of substantial unauthorized populations in their countries? So, of course, the main question is, well, how does this affect policymaking toward this question of irregular, or what's often called illegal, immigration? So, this is a comparative project that looks at France, Germany, and the UK at kind of two what we call critical junctures. The first being the 60s, which was the period preceding the larger closure of work and post-imperial immigration in Western Europe, which happened kind of in the early 70s in a lot of different countries for various reasons. So looking at that era really is the one in which the issue or the social problem of irregular immigration emerged as something that policymakers and the political system were aware of. And then also looking at what I would call the long 90s, so kind of the end of the Cold War period stretching into maybe the beginnings of the last decade. So during this period, a lot of important ways of thinking about immigration policy problems in Europe kind of became set among policymakers. And so we want to look at that period in particular as policymakers in a lot of different countries were dealing with new flows of migration in the post-Cold War context to understand how they regarded irregular immigration, how this fit into the larger scheme of regulating migration in this environment. So to talk about the UK specifically and to discuss the 1960s period especially, so I went to the Kew National Archives, the National Archives in Kew, and collected about 10,000 pages of archival documents, mainly from the Home Office from the period of 1963 to 1973. Archival sources are usually seen as kind of a historical source or prone to historical methods. They're not used as much in social science, but they actually can allow really great insight into the exact deliberations that policymakers were going through around certain questions at certain times. And so just to, really to highlight what came out of these documents for me in the 1960s is, so there was a system for Commonwealth immigrants, right, so immigrants from the former empire, which was set up in 1962. Previously, there had been no legal limits on Commonwealth migration to the UK because of the nature of UK citizenship law and various other reasons. But this system was very intentionally light on individual scrutiny. So it can kind of boggle us today when we think about how immigration control works to say, well, basically the way it worked is that people showed up at the port and said, well, either they could have a labor voucher, right? They could be a primary labor migrant, or they would say, You know, I'm the spouse or the child of somebody already settled here, somebody from the Commonwealth. And this was an entirely ports-based system. There's very little documentation required. You needed a passport to cross through, but you know, oftentimes during this period, children, for instance, would be within their parents' passport. They didn't have a separate document. And once Commonwealth immigrants came into the UK, there was very little monitoring of them in a systematic way once they were there. They were free to work any job they wanted, to settle permanently, to live wherever in the country they wanted to. And there was no real monitoring of them. And this was a very intentional system, both because the Home Office thought they didn't have the capacity to do this kind of monitoring, and because they thought it would be averse to other social goals like integrating this population. But under political pressure, kind of more punitive and individualized systems did emerge. So the 1962 Commonwealth Immigrants Act had no concept of illegal immigration from the Commonwealth. It was not illegal if you were a Commonwealth citizen to get on a small boat and cross the English Channel and land. That wasn't against the law. You hadn't committed a criminal offense. If you showed up at a port, an immigration officer could send you back if they didn't think you met the criteria, but it wasn't an offense to avoid immigration control entirely. But under political pressure over time, there was an increasing concern about what was at the time called evasion of the control. And so you started to see somewhat more individualized and punitive approaches emerge. This is the topic of this paper, which by me and Christina, which was the first one to come out of the project, really discussing, okay, so the concept of symbolic policymaking in immigration. So it does make it a more general contribution to that. But in terms of the kind of more immediate political relevance, what we explored were these instances of the alleged tightening of immigration control, where the Home Office didn't think it would make any difference to their ultimate goal of reducing immigration, right? So when they had the debate around the question of, well, should we make clandestine immigration from the Commonwealth illegal, the Home Office thought, well, we're talking about, you know, maybe a couple hundred people. This is a drop in the bucket of what we regard as a numerical problem. But nonetheless, they did it because it was politically expedient. And so what this really exposes is just how different the system operating in the 1960s was to what we would expect of immigration policy today, where there's much more thorough monitoring in the UK of immigrants from basically everywhere except, well, so far, the European Union. So while this does make a general theoretical contribution to ideas of symbolic policymaking, where it's kind of been most relevant is in the context of the Windrush Scandal and the hostile environment. So that paper initially came out last April, right around the time that the Windrush Scandal was breaking. And the thing that this research has really revealed about, in the context of the Windrush Scandal, which of course involves mostly people who came to the UK largely in the 60s, somewhat before, really the children of the Windrush generation rather than the Windrush immigrants themselves, is just how document light that system was, because it was not meant to control individual migrant movements, but to govern the problem in mass. So they saw it as a problem that there was too much immigration. They didn't think that punishing individuals was going to get them anywhere, so they didn't make a system that was aimed to do that. Now the expectation is that everybody is going to be very well documented, but that didn't exist at the time. And they had purposefully not subjected this population to that kind of system because they didn't think that it would suit either their control goals or it would facilitate integration. They thought that it would create a kind of a second-class citizenship that would be bad for what at the time was largely considered under the rubric of race relations. So the logics of earlier systems what we found have been really institutionally forgotten, because when we went back and talked to policymakers from the 90s, there's no recognition, for instance, that it's a different thing to scrutinize individual eligibility and punish individual immigrants than to limit immigration flows, right? There's no concept that those things were different, even though this was very clear to the 1960s policymakers when you look at the documents. And the Home Office these days really doesn't have any institutional knowledge of what came before, right? They're obviously still dealing with a lot of people who came to the UK during this period, but nobody there really has much memory of what it was like. So I've been to the Home Office twice to talk to them about the legacies of these systems, right? And just how different the logics were, and just how profoundly surprising from today's perspective the expectations surrounding, for instance, documentation would be. somebody might have come in on their parent's passport. Nobody thought it was important to keep it because this was not part of the logic of the system. So I've spoken to, for instance, the Windrush Lessons Learned review staff. That report hasn't come out yet. Some of it has been leaked to Channel 4, which I don't know what exactly that means for the viability of the report. But it does suggest that, the leaked excerpts do suggest that they've really taken these historical lessons quite seriously. To talk about kind of future directions of this research, so working more in the 1990s period, we're discussing, for instance, what is the logic of the increasing link between welfare policy and immigration. So we're looking at this in a comparative perspective across the UK, France, and Germany. Maybe it won't surprise you, but what we find is that nobody thinks about welfare at all, really, when they're adopting these policies. It's all about the idea of immigration control and the reduction of rights for immigrants, exerting some kind of downward pressure on numerical flows. Something I'm working on that's somewhat related, which relates to both periods of the UK case, is this distinction between scrutinizing and punishing individuals on one hand, and trying to reduce immigration numerically on the other. Because when I've spoken to the Home Office staff, I've said that until you grasp that the 1960s policymakers saw these as completely different ways of governing immigration that actually had sort of opposite aims, because once you commit yourself to individual scrutiny and fairness, how do you cap the numbers, right? They say there's no inherent way to do that. This runs averse to the logic of the system. And until you understand that they saw these things as differently, whereas today, for instance, if you talk about the government's net migration target to bring immigration or net migration under 100,000, which they've never come close to achieving, the way that they've tried to do that is mainly through tightening individual eligibility and scrutiny. And 50 years ago, the people who were working on these issues 50 years ago would say, of course that won't work, right? But there's no consciousness of this that remains. And I think that the elision of these two separate models into kind of one idea of reducing immigration by scrutinizing individuals has had really profound implications both upon the failures of government to enact the migration controls numerically that they've promised, and for immigrants' rights. And that's something that I'm working on coming out of this as well. And in addition, excitingly, there are new documents that are coming out from the 1990s. A lot of the policymakers that I spoke to from that period, before the Windrush Scandal broke, importantly, quite freely associated certain developments that happened there in terms of joining up immigration control with welfare and work bureaucracies with the 2014 Immigration Act and what we would now call the hostile environment. I don't think that they'd make those associations as freely now. I think they'd be quite scared to do that in the context of the Windrush Scandal. But fortunately, for research purposes, new documents are coming out from this period. So intending to go down to Kew and to look at what people were saying at the time, which should be really interesting. And beyond this, there should be a book by the five of us coming out maybe 2021, so stay tuned for that. Okay, any questions?